When you die, your superannuation does not automatically go to your family. It doesn't go to your spouse. It doesn't go to your children. And it does not go through your will. No matter how carefully that will was written, no matter who witnessed it, and no matter how clearly it spells out your intentions. Most Australians have no idea. This is how the system works, and the families who find out the truth usually find out at the worst possible moment, when they are already grieving, already exhausted, already managing 100 things at once, and completely unprepared for what comes next. Today I'm walking you through exactly what happens to your super when you die, the 7 situations that leave Australian families worse off than they ever needed to be, and what you can do right now, while you still can, to make sure the people you love actually receive what you spent 40 years building. Australia's superannuation system holds over $3.9 trillion in retirement savings. For most Australians, super is their single largest financial asset, larger than their car, larger than their savings account, and in many cases larger than their share portfolio. But superannuation is not a normal asset. It sits outside your estate, which means it operates under its own entirely separate set of rules. Rules that are completely independent from your will, your power of attorney, and every other legal document you have ever signed. The trustee of your super fund, not you, holds the ultimate authority to decide who receives your super when you die. That authority can be overridden, but only if you've taken specific steps, in the right order, and well in advance of when they are needed. Here are the 7 situations where ordinary Australians get this wrong, and what each one costs the families left behind. This is the most common situation, and arguably the most dangerous, when you have no valid death benefit nomination on file. Your super fund trustee holds full discretionary power over who receives your balance. They will look at your dependents, defined under super law, as your spouse, your children, anyone financially dependent on you, and anyone in an interdependency relationship with you, and they will make a judgment call. That decision may align with what you would have wanted. It may not. There is no legal requirement for it to match your intentions. A trustee might split your super between your spouse and your adult children in proportions you never imagined. They might delay distribution for months while investigating your personal circumstances and financial relationships, and your family has very limited legal grounds to challenge that decision once it's been made. In 2026, the ATO estimates that a significant proportion of Australian super fund members, potentially millions of accounts, have no binding death nomination in place whatsoever. If you are one of them, your super fund currently has more legal say over where your retirement savings go than you do. That is worth sitting with for a moment. A binding death benefit nomination is the legal document that removes the trustee's discretion entirely and directs your super to specific people in specific proportions. It is one of the most important financial documents you will ever sign. It is also one of the most frequently forgotten. Standard binding nominations in Australia expire every 3 years, automatically, without warning, and without any notification from your fund. Once they lapse, your nomination becomes non-binding, which means it shifts from a legal instruction to an advisory suggestion, and the trustee's full discretion returns immediately. Many Australians signed a binding nomination when they first opened their super account, or when they had their first child, or when they got married, and have simply never looked at it since. If it was signed more than 3 years ago, and you haven't actively renewed it, there is a real possibility it is no longer binding today. Some funds now offer non-lapsing binding death benefit nominations, which do not expire and remain in force until you actively change them. If your fund provides this option and you haven't switched to it, that is the single most important administrative task you can complete this week. Log into your super account, locate the death benefit nomination section, check the expiry date, and if it has lapsed, act on it today. Life changes constantly, and most Australians don't update their super nominations. When it does, a nomination that made complete sense when you were 35 may be entirely wrong by the time you're 55. If you named your ex-spouse as your beneficiary and never removed them after your divorce, they may still be legally entitled to receive your super, because your nomination, not your divorce settlement, and not your intentions, is what the fund is legally required to act on. If you named your parents as beneficiaries when you were single in your 20s and now have a spouse and children who depend entirely on your income, your parents may receive your full balance, while your immediate family receives nothing. And if you named a sibling, a close friend, or anyone else who is not classified as a dependent under super law. The trustee may not be able to pay them at all, which forces your super back into your estate, where it becomes subject to delays, potential creditor claims, and legal costs your family never anticipated and never planned for. The people named in your super nomination must be either a dependent under super law or your legal personal representative directing funds through your estate. Anyone else creates a complication. Check your current nomination against your actual life today, not the life you were living when you signed it. This is the single misconception that causes the most shock, the most confusion, and the most family conflict. Australians spend considerable time and money preparing a will that clearly outlines exactly who should receive what. They name their spouse, they name their children, they specify their property, their investments, their savings, their personal belongings, and then they assume, completely reasonably, given how the rest of the legal system works, that their superannuation will simply follow those same instructions. It won't. Super sits entirely outside your estate, unless you specifically direct it there, through a nomination to your legal personal representative. If your super goes directly to a named beneficiary, it bypasses your will completely and arrives at that person's hands, regardless of anything your will says. If your will and your super nomination conflict, which they do far more frequently than most people realize, the super nomination wins every time. For blended families, this creates particularly serious and sometimes irreparable consequences. A parent in a second marriage may hold a will that carefully provides for children from a first marriage, while a super nomination directs their entire balance to their current spouse, leaving the children with no legal claim whatsoever on the super. Regardless of what the will explicitly states, your will and your super nomination must be reviewed together by someone who understands both documents, and they need to tell a consistent story. This one surprises even financially literate Australians. When super passes to a tax dependent, a spouse, a minor child, or someone genuinely financially dependent on you, it is generally received entirely tax-free. But when super passes to an adult child who is not financially dependent on you, they pay tax on the taxable component of your super at 17%, comprising 15% tax plus the 2% Medicare levy on a $400,000 super balance. With a fully taxable component, an adult child receives $332,000, not $400,000. The $68,000 difference goes directly to the ATO, not to your family. This is not a widely understood outcome, and many Australian families discover it only after the estate is already being distributed and the tax assessment has already arrived. There are legitimate legal strategies to reduce or eliminate this outcome, including drawing down super before death and moving funds outside the super environment, converting from accumulation to pension phase, or directing super through the estate in specific and carefully structured ways. But every one of those strategies requires planning well in advance, with professional advice, and cannot be applied retrospectively. If you have adult children you intend to include in your super death benefit, this specific conversation with a financial advisor or tax agent needs to happen now, not when the paperwork is being processed. For Australians already in retirement, drawing a pension from their super, there is a powerful and underutilized tool called a reversionary pension nomination. When you establish a reversionary pension and nominate your spouse, your pension income continues paying to them automatically upon your death, without interruption, without the fund needing to investigate or make a decision, and without the administrative delays that typically accompany a standard death benefit claim process. This continuity matters enormously in practice, because the alternative, your spouse receiving a lump sum death benefit payment, triggers an immediate tax assessment, requires them to make complex financial decisions during an already overwhelming period of grief, and can create unexpected Centrelink implications if the lump sum pushes their total assets above the age pension threshold. In 2026, the transfer balance cap sits at $2.1 million. A reversionary pension counts against your spouse's transfer balance cap upon your death, which does require careful planning to navigate. But for the vast majority of Australian retirees, the continuity of regular income and the significant reduction in administrative burden makes a reversionary pension a far more protective outcome than a lump sum payment. If you are currently drawing a super pension and have not reviewed your reversionary nomination recently, that review needs to happen before anything else does, even when a death benefit nomination is valid, current, correctly structured, and perfectly aligned with your intentions. The process of claiming super after someone dies still takes time. Funds legally require death certificates, identification documents for all claimants, proof of relationship to the deceased, completed claim forms, forms, and in some cases, statutory declarations, all submitted correctly, all consistent with each other, and all processed by a trustee team that may be managing hundreds of similar claims simultaneously. When any piece of that paperwork is incomplete, inconsistent, or simply missing, which happens routinely in unplanned situations, the process extends from weeks to months. Families managing mortgage repayments, school fees, utility bills, and everyday living expenses without the deceased's income cannot always afford to wait that long. The practical solution is simple, costs nothing, and almost nobody does it. Keep a document stored with your will, clearly accessible to your executor, that contains the full name of your super fund, your member number, the name and direct contact details of your fund's claims team, a copy of your current death benefit nomination, and a note on whether you hold any insurance inside super that may generate a separate and additional claim. That single document, prepared on an ordinary evening, can reduce the claims process by weeks and save your family thousands of dollars in legal fees, financial stress, and unnecessary delays at the worst possible time in their lives. 7 situations, every one of them preventable. Here is exactly what to do. First, log into your super account today and find your death benefit nomination. Check whether it exists, whether it is binding or non-binding, and when it expires. Second, if your nomination is more than 3 years old or no longer reflects your current life, update it immediately and ask your fund specifically whether a non-lapsing binding nomination is available. Third, review your nominated beneficiaries carefully against your actual dependents today, not who they were when you signed the form, but who they are right now. Fourth, if you have adult children you intend to leave super to, speak to a registered financial advisor about the 17% death benefit tax on non-dependents and whether legitimate planning strategies are available to you. Fifth, if you are already drawing a pension from your super fund, confirm whether you have a reversionary pension nomination in place and whether it accurately reflects your current wishes. Sixth, review your will and your super nomination together. Confirm they are consistent, and confirm your super does not accidentally override or contradict what your will intends. Seventh, prepare a simple one-page document for your executor containing your fund name, member number, nomination copy, and claims team contact details, and keep it somewhere your executor can find it when it matters. Superannuation is the largest financial asset most Australians will ever own, and yet it is the one asset that most people have given the least thought to when it comes to what actually happens after they are no longer here. The rules are not designed to be cruel. They are designed to protect beneficiaries in the absence of clear instructions. But when clear instructions exist, documented correctly and kept current, the system works exactly as it should. The families who go through this process smoothly and without conflict are not the ones who were lucky or wealthy or legally sophisticated. They are simply the ones whose loved ones took 2 hours on an ordinary afternoon to get the paperwork right. That is genuinely all it takes. If this video gave you something to act on today, subscribe and hit the notification bell. More straight-talking Australian finance every week. Thanks for watching. I'll see you in the next one.